have Ramadan Abubakar.
Present, my lord.
And we have Madam Rebecca Omwenga.
Present, my lord.
My lord, we are the ones who moved the court, so we could speak first. It is all clear.
May I please, I am just again, I don't know, commitment to say good morning, or we have said good morning already. My lord, I will make an application very respectfully. That you join Kituo Tesseria to the proceedings.
So if you want to speak, we'll let us.
For many years, my lord, Kituo Tesseria.
It's okay.
Regularly within the country for constitutional reasons. And for independent judiciary. So now, the enjoys itself from time to time in cases to the High Court. And there's never been a problem or any issue for any court or any judge enjoining Kituo Tesseria at all. But I may say this, Your Honor. We Kenyans wear what we wear at the moment. And among nations of the international community, because of upholding the rule of law and respecting constitution. If I may.
Mr. Counsel, I really don't want to cut you short because I need to.
Sorry, if I join up, I would say it's more.
So can you make it short?
Yeah, Your Honor, with that injunction, I will go any further. If you didn't join me, Kituo Tesseria, and that day Kituo
Tesseria. That's why I'd asked that you allow us to speak first, because we're the ones who move the code. Some of the things we'll say may...
I saw you have an application in 2017.
Yes.
Where you want a constitution change. There's an application from your end.
Yes, we filed an application to that effect.
Today you appear before Justice Winter.
On that application?
Yes.
Before
Justice Winter, who placed the matter
before you. Yes.
So you are the people to tell me why I am here.
Very well.
Then, who asked for this matter to be mentioned before me today? Was it your application or was it the rest of the
My lord, I'd like to respond to you, and I kindly request my lord to take his seat.
Okay.
Yeah, let's find out who went before Justice Winter yesterday for the Winter to direct the matter to be mentioned this morning.
It is us.
May it please you, my lord.
And then after that, I went to the CPS and I found there was also an application which I gave direction that I should be giving it to the society.
Okay.
May it please you, my lord. I forgot to put on record Mr. Bita and Mr. Mutinda from the Office of the Attorney General. My My Lord, when parties appeared before Justice Muita yesterday morning, we made an application, requested the judge to allow us to produce before the court the Deputy Inspector General, as was directed by Your Lordship on the 13th. And we did that because the 7 days window that was given was going to lapse today. And for that reason, Justice Muita directed us to appear before you this morning for the matter to be mentioned. For the sole reason that this mention is for purposes of producing the Inspector General before the court as directed. I wouldn't have said the next sentence because I thought it was going to be easy, but I'm going to do so. That this is post-sentence appearance. And for that reason, the petitioners are not properly before you, and even if they are, they do not have audience. Your order, my lord, was self-executing. It would have been operational whether or not the parties were before you. Thank you. And if you will rule on that, as a tutelar head of the bar, I think I have the right to address you first. This is not only as a matter of practice, but it is also pronounced in the Attorney General's Act. So I will let you rule accordingly.
Petitioners are before the court. They have a right to address the court on any matter that is before it. They cannot be guarded. Okay, which application are we dealing with?
We are dealing with the application to...
We are looking at
appearance of
the
before the court.
Inspector General of Police. Eh?
Yes.
Okay, I think we should allow, let me hear you, and then I will hear the Law Society, and then after that we will see the way forward.
What about me, my lord?
Dr. Amino, you see, because of your age, I have always told you that I really respect you. And yes, so kindly, would you kindly do a formal application? Yes, I will request you kindly do a formal application. I didn't want to address that first because you see now the proceedings we have today, you can see the kind of matters we have. We must have to deal with those issues first. Then we can deal with other applications later. It is not possible for us to deal with all these applications that might arise now. So I will request that you go and do a formal application.
I file a formal application.
Yeah, serve it to them.
I'm not opposed to doing that.
Yes.
The only thing I would like to point out respectfully that your brothers and sisters have been admitting Kituo cha Sheria. It's not me really, Kituo cha Sheria.
I have not refused to admit
without
it.
a form of application.
Don't worry, I have not refused to admit Kituo cha Sheria. Only go and do a formal application and I'll be able to look at it.
And then by the time I arrive, the court will have adjourned.
I'll just go do it, post it, I'll give directions online. I will give my directions online. You don't have to come. Yes. Right, thank you. Thank you so much, Dr.
May it please you, my lord, in this matter, the Attorney General was initially on record for the respondents, in particular, regarding the orders made initially on the 23rd of August 2024 and the 13th of September 2024. Then they were. Then the first respondent was represented by Waziri Gongo, but today Mr. Ogola and Mr. Miller are now here on record for Mr. Masengeli because content proceedings have now been cancelled. Also attending court today is Deputy Inspector General of Police, Mr. Gilbert Masengeli. He does so in compliance with the order of court issued on the 13th of September 2024. And this is within the time span prescribed by your Lordship in the order your Lordship had generously and graciously directed Mr. Gilbert Masengeli can avoid serving the sentence if he complies with the direction to obey the court summons. I thus suspend this sentence for 7 days only. The Acting Inspector General of Police can redeem himself and comply by availing the issues he has been avoiding within 7 days. In default, the sentence shall automatically become effective. End of quote. My Lord, the court summons in question and bespoken by your Lordship in that order, and to which the first respondent was to answer, had been made on the 26th of August 2024, in which your Lordship rendered as follows. That summons to issue to the first respondent to appear in court on the next mention to explain why the habeas corpus orders issued by the court were not complied with. The matter was fixed for mention on 3rd of September 2024. My Lord, it is our first duty to explain the reasons why hitherto Mr. Masengeli has been unable to make a personal appearance in court in answer to the court summons. This inability has been misrepresented by both the petitioners and certain press reports. It has widely, but incorrect, been alleged that the summons thereby issued have been either ignored or defied.
Are you explaining that on this one?
No, I'm not. I'm talking generally.
She's reading a speech.
Just a minute. Thank you.
Thank you, my Lord. My Lord, I'm saying that because the misrepresentation and the miscorrections not only affect the respondent, Mr. Masengeli, as an individual, but they also affect the executive and other branches of government. So it is not just a personal matter. it has widely but incorrect been alleged that the summons thereby issued have been either ignored or defied, reportedly as an act of arrogant disregard for this Honorable Court's authority and its constitutional mandate. Nothing could be further from the truth, and regrettably, it has not been possible to proffer a full explanation of the situation until now. My Lord, on each occasion when the personal attendance in court by Mr. Masengeli was required, he was disabled from doing so by pressing exigencies of duty out of Nairobi, and on each such instance, discreet attempts were made to communicate these difficulties to court without having to disclose delicate and sensitive operational detail which were of national security nature. When the orders of 26th of August 2024 were served on the first respondent on the 29th of August, Mr. Masengeli, in his capacity as the acting head of the police service, was already in Lamu on official duty when the orders of 26th of August 2024 were served on the first respondent on the 29th of August. Mr. Masengeli, in his capacity as the acting head of the police service, was already in Lamu on official duty. As is now common public knowledge, that region suffers from a very tenuous security situation. Mr. Masengeli and other national security operatives had traveled to attend to urgent security concerns. Accordingly, the Director of Legal of the National Police Service, Mr. Charles Otiende, was detailed to attend court at the next mention of the matter on the 3rd of September 2024. He was to inform the court of the circumstances under which, thus far, the first respondent had been incapable or disabled from complying substantively with the habeas corpus application. However, the official was seized with information which would reply to the court's questions relating to the habeas corpus. The instructions to Mr. Otiende were issued on the understanding that, on a reasonable reading and construction of the order of 26th of August 2024, the first respondent could be represented in court by any competent officer or official. Mr. Masengeli had also been advised that the court proceedings on the 3rd of September were scheduled to be virtual and that the representative of the first respondent could attend virtually. My Lord, in a further effort to assist the court in its inquiry, the respondents filed an affidavit on the 4th of September 2024 in reply to the ones filed by the petitioners. In his affidavit, he set out an account of how the first respondent received a missing persons report and the ongoing investigation measures that it was undertaking to trace the whereabouts of the missing individuals. My Lord, when the matter was again mentioned in court on the 5th of September, Mr. Masengeli was still engaged in the security operations in the coast region. He provided an affidavit and affidavit evidence to this effect as Annexure GM2. This was the relevant police signal with OB numbers indicating the brutal murder of 4 men in Taita Taveta, Tana River County, presumably as a retaliatory attack in an ongoing clan dispute which was spiraling out of control. As a result, the first respondent was represented in court by the aforementioned counsel, Mr. Otiende. Mr. Simon Kirui, the officer in charge of Directorate of Criminal Investigations, Kitengela, also attended, and Mr. Joseph Indeke, the investigating officer in the subject matter of the disappearance, also attended. After the court proceedings of the 5th of September, it was understood that Mr. Masengeli's personal attendance in court was required on 9th of September.
On which date? 5th.
After the 5th, yeah? The affidavit was filed on the 4th, but on the 5th it was clear that Mr. Masengeli's personal attendance in court was required on September 9. or 9th of September. However, in the interim, the security situation had deteriorated considerably and increased in its complexity. As demonstrated by annexures to Mr. Misangeli's affidavit marked GM3. It is a police signal, complete with OB numbers, indicating an Al-Shabaab attack on one of the police stations in Wajir County, which event demanded Mr. Masengeli's, with other senior security personnel, personal attendance. My Lord, national security is the protection against internal and external threats to Kenya's territory and territorial integrity and sovereignty. It's the protection of Kenya and its people, their rights, freedom, property, peace, stability, and prosperity, and other national interests, as enshrined in Article 238-239 of the Constitution. All institutions of and in the Republic exist under the aegis of a secure sovereign military. The primary object of any national security organ and security system, including the National Police Service, is to promote and guarantee national security in accordance with the principles mentioned in Article 238(2) of the Constitution. The fundamental nature of national security cannot therefore be overstated. But it is also equally fundamental and a fundamental constitutional principle that the national security organs are subordinate to civilian authority, Article 239(5). That is why, despite the excruciating and heavy security demand upon him at the material time, Mr. Masengeli nonetheless saw it fit that the DIG, Mr. Eliud Lagat, attends court on the 9th of September, and he attended. For the first respondent, he wasn't given audience, and it now transpires that, given the specificity of the orders issued by the court latterly, and quite understandably, Mr. Lagat could not and did not have audience before the court. When the court sentenced Mr. Masengeli on the 13th of September 2024 for contempt of court, he was still in Marsabit County coordinating security operations. Annexure 4, G4, in his affidavit, is a police signal with OB numbers indicating that an unknown number of armed militia had attacked a bus.
When the court sentenced him, where was he?
Sorry?
Where was he at the time of the sentence?
Or when the court sentenced on the 13th of September, he was still in Marsabit County, my lord, coordinating security operations. And that is evidenced by Annexure 4, G4, in his affidavit, which is a police signal. It has OB numbers, indicating that an unknown number of armed militia had attacked a bus service vehicle registration, KCX 039N, and had sprayed it with bullets with catastrophic results. My lord, the main objective in setting out the foregoing facts in extenso is not to excuse the failure by Mr. Masengeli to attend court. It is hoped, however, my lord, that it will demonstrate that he did not deliberately degenerate this honorable court, as has been characterized by counsel for the petitioners and others, nor do the facts show that he did not recognize the authority of this honorable court. The apology which he wishes to tender and duly tenders to this honorable court today is without reserve. It was clearly tendered earlier in his affidavit of 12 September 2024, and it is repeated here. In my humble submission, my lord, I plead with this honorable court to take into account The extenuating circumstances narrated by Mr. Masengeli in his affidavit My Lord, this is not just a simple instance of clash of loyalties. It is rather a case of a security official caught up in the horns of a dilemma, whilst in the midst of a serious and delicate security emergency. It is easy in such circumstances for one, perhaps without deliberate intention, but instinctively, to gravitate towards national security operations over personal tribulations. My Lord, it is on this basis that we plead with you to exercise your judicial discretion to incline towards grace. My Lord, may you temper justice with mercy in the realization that the actions of Mr. Masengeli in his case were not sheer or brazen, but of loyalty of a citizen gone weary in the course of doing his best in a bad situation to serve two pressing and seemingly equally demanding solemn duties. I further plead with you to take into account the contemptor's promise to file regularly a progress report on the investigations regarding the missing persons or any update therefrom. Thank you, my Lord. Thank you for giving me audience. The last time I appeared before you, it was in a different capacity. I'm grateful you gave me that audience. Thank you, and I'm obliged.
Mr. Amir.
Yes, my Lord. I wish to inform the court that Mr. Masengeli is present and ready to take the stand to explain himself, as was directed by the court. I am praying that he be sworn in so that we can lead him through the process of complying with the court's order, my Lord.
I will go to the petitioners now. I will also give you time to address the court.
My Lord, I've listened to what the Attorney General has said. 2 points were outstanding. She said that there were discreet attempts to reach the court to explain serious matters of national security. Why these discreet attempts? What the court makes out of those statements we leave it to the court. But from our side, we find it extremely deplorable that the office of the Attorney General will admit that there was interference with the judge insofar as this matter is concerned. We'll leave it at that for now. Number 2, the Honorable Attorney General.
My Lord, I wish to take objection. Kindly, I wish to take objection.
What is the objection?
That is a very major accusation. May please take your seat. That is very major accusation. And he has to put on record where I said that there was effort, or where I was admitting that the judge was interfered with as the Attorney General. And from my statement, where I admitted that there was interference with the judge.
Mr. Nelson Havi, did you?
My Lord, number 2, I'm old enough not to be distracted from my life.
Kindly respond to that. It is important. You have made a very serious
She has a written speech where she said there were discreet attempts to reach the court to explain the delicate nature.
Given a dictionary to define the word attempt.
Okay. What did you hear from the council for the 8th?
No, I will not withdraw. We are on live camera. They will play that clip if she says she didn't say it. But I've finished what I was saying for issue number 1. Let me go to number 2. You can go back to your note. She said there were discreet attempts.
Attempts?
Yes. Please, respect your office. It's
Well, I can't see it, but
so okay. Watacheza kwa Citizen jioni will hear it. So, number.
I think Mr. Havi, you know, we are. This is a court of law. The public is watching. Kindly let that. As a judge, I can say that. Well, maybe it has missed. I have missed it, but I don't think I have heard that.
Okay, the court may not have heard.
I may not have heard that.
But we had it.
And if there were discrete attempts, then I don't know where they were being made.
It's okay, my Lord.
Yeah.
Could you allow me to go to number 2?
But let's proceed.
Yeah, I'm not apologizing, friends. We're dealing with a serious enterprise here.
Since you are reading a statement,
Yes.
Is it in your statement that you are making discrete attempts to approach the court or something?
Hello.
What is it that you said so that it is clear for the record? Because I may not have captured each and every word.
Lord, if they can make a copy, they can supply a copy to the court of what they have said to adhere to.
Yeah, let's find out.
I said there were discrete attempts.
We have a right to respond to the speech.
Give information to the court
given.
on national security matter, and I stand by that because national security matters cannot be written and cannot be said in public. And if it is a matter of national security, all 3 arms of government collapse into one, and it can be related.
All right. I didn't hear. I think then Mr. Abi is correct.
Here's a great, my Lord. You know, she was reading, I was listening.
It was an attempt, it didn't.
Yeah, it was an attempt. An attempt is as serious as a committed action. So, my Lord, permit me to finish. I'll be very short.
Yeah, proceed.
Yes. So the second fundamental issue I picked from her written speech, which she read, the submission, was that the heavy matters of national security demanded the presence of Mr. Gilbert Masengeli there, as opposed to what was otherwise personal tribulations that he was to meet in court. And my Lord, this background is important. It is important for this reason. Lord, very early in the morning, we heard of reports published by none other than the President of the Law Society of Kenya, Madam Faith Moni Odhiambo, that the 3 petitioners had been released and dumped somewhere in Russia. There is a background to it, my lord. Just be patient.
They have been released. No, I'm from court. I'm not able to see what is happening.
Yes.
What are you saying?
If you could just be patient, you'll get to hear what I'm saying. So, my lord, it was our expectation today that the respondents will come and say, and we still expect them to say, that the first order for habeas corpus has been complied by us, and here before the court are the three. Relax. And if at all they have complied with the habeas corpus and produced the three, then this litigation will come to a natural end. So we'll be happy if we'll be told that that is the case, because we've just seen this reports. Number two, my lord, on the substance. Subsequent to the conviction and the sentence, Mr. Gilbert Masengeli approached the Court of Appeal on two civil applications.
Approach the Court of Appeal?
Yes, on two, sorry, not civil, on two criminal applications. One is Nairobi criminal application number E466 of
criminal application number
466. My lord, if you could kindly ask them to be quiet, because I need to make these submissions in quietness.
Yes, let's maintain silence.
Yeah, it's not parliament or a public rally.
Yes, proceed.
Yeah, the first is criminal application number E466 of 2024. Mm-hmm. This criminal application seeks, in the main, to stay the order convicting Gilbert Masengeli of contempt of court. Number two, before the Court of Appeal, is criminal application number E471 of 2024. In this second criminal application, Gilbert Masengeli and the rest of the team have sought an order before the Court of Appeal to suspend and stay the sentence made by this court upon conviction. My lord, indeed, these two applications were before the Court of Appeal yesterday. And they have been, yesterday? The Court of Appeal on Wednesday, the day before yesterday. And they have now been rescheduled for hearing next week, for a date that will be given by the President of the Court of Appeal. So, my lord, the derivative from the developments at the Court of Appeal are this: that the Court of Appeal is now seized of the twin question of the conviction of Gilbert Masengeli and the sentencing of Gilbert Masengeli. And for that reason, Lord, the jurisdiction that this court had can only await the Court of Appeal's decision on those two applications. Further, my lord, those developments before the Court of Appeal have an impact on the suspended nature of the sentence this court meted on Gilbert Masengeli. The nature of that suspended sentence is therefore before the Court of Appeal. So, my Lord, with those circumstances, this court can only do two things. One is to hear from Gilbert Masengeli on how he has complied with the order for habeas corpus, because he's here. And if he has complied, as we have read, then of necessity these proceedings must terminate. Or if they don't terminate, then they must be held in abeyance, awaiting the outcome of the challenge against the order for conviction and the order of sentencing. That, my Lord, in my humble submission, is what should happen today. I don't know whether any of my colleagues would like to speak.
Anyone from the petitioner side? Okay. Let's get a rejoinder from.
My Lord, the Vice President of the Law Society is here.
All right.
Let me put him on record first, and of necessity, he must speak. Just to say he has something, or if he doesn't have anything, then he will say as much.
Your name?
I must abide by.
Maura Kabata.
Okay, say something.
My Lord, the President Emeritus having a summary is what we have to say. Just for record, I was attending the admission of advocates. That is why I did not come in good time. But as a law society, we are eager to see this matter concluded to its logical conclusion in the procedure and the framework that this court deems fit with the nature and the weight in our petition. That is all, my Lord.
My Lord, with your kind permission, the summary of what the Law Society of Kenya is saying is that this court is functional sufficient. It has already concluded this matter. It is pending before the Court of Appeal. And the moment it goes to Court of Appeal, the jurisdiction changes and the matter at the Court of Appeal has to be dispensed with first before the proceedings here go on. My Lord, the last one is that the issue of conduct of court has now been personalized between the judge and the convictee. And therefore, the convicted person has to comply first before they have audience of this court. They have to show that they have obeyed the court, then the court can hear them. I thank you, my Lord.
Mr. Miller.
Yes, my Lord, a brief reply. The one thing that we must take into account is the orders that this court gave on the 13th of September. The orders, my Lord, had a rider. And the rider was that Mr. Masengeli could avoid sentence if he appeared before this court within a period of 7 days. My Lord, the court defined the order as a coercive order. My Lord, this court's order is still in existence. The 7 days have not expired. We actually moved the court yesterday before the presiding judge. And we were ready to produce Mr. Masengeli even yesterday. It is the presiding judge who directed that we mention the matter before you for production, in compliance with the orders of this court of the 13th of September. My Lord, the Court of Appeal matters in question that have been referred to by my learned colleague do not have, first of all, are not heard on the basis of the fact that the petitioners who are respondents therein were not ready to proceed. And as a result of that, my Lord, no orders were granted by the Court of Appeal. As it is right now, my Lord, the matters in the Court of Appeal do not even have a date. To go the way the Law Society petitioner herein are suggesting to this court would be a gross violation for the first respondent's constitutional rights to a fair hearing. My Lord, you're still seized with jurisdiction as per the order you granted on the 13th of September. Your order is still alive. It has a compliance clause, and that's why Mr. Masengeli is here. And therefore, my Lord, to say that the matter is terminated is premature and a misconstruction of the order of this court of the 13th of September. Most importantly, my Lord, the petitioner's counsel, Senior Counsel Harvey, has indicated in his submissions to this court that the missing petitioners have been found. My Lord, surely the fair thing to do now would be to allow Mr. Masengeli to take the stand as you directed, to explain the circumstances as per your ruling, and most importantly, my Lord, to deny him that opportunity on the basis of the submissions of the petitioner in the face of the admission that the missing persons are alive and well would be a gross miscarriage of justice, my Lord. Would be sending him to prison for nothing. I therefore pray that you allow us to put Mr. Masengeli on the stand in keeping with the order of the 13th of September, which has not been varied, set aside or stayed by any court, so that we can comply with the orders of this court, my lord. That's all.
My lord, permit me to distinguish the application at the Court of Appeal as against the proceedings before this honorable court. It's disturbing that we appear to be approbating and reprobating the jurisdiction of this court. Is there an order injuncting these proceedings? No. Does the court have the power and authority to entertain today's proceedings? The short and straightforward answer is yes. The application at the Court of Appeal is only one. Mr. Masengeli has filed only one application and no appeal yet. That is application number E7471 of 2024. He seeks to overturn or to stay the conviction, but would be happy to be guided if these proceedings can discharge the conviction. My lord, our understanding of these proceedings and the orders are clear. This being a court of record and a court of sequence, this is the sequential order that the court directed. Number one, a sentence be and is hereby imposed of 6 months. Number two, that sentence be and is hereby suspended for a period of 7 days. On condition that the contemnor within the permitted period appears before this honorable court, which he has done, apologizes, which is why my learned senior Mr. Miller is saying that it should be sworn in so that he can adopt his statement and apologize, and then purge that content, in which case the court would exercise its discretion to release him ex debito justitia, having explained himself and having been pardoned, therefore free to go. My lord, the direction that commends itself at this stage is that by the presence of the contemnor here in court and yesterday, what follows that sequentially, my lord, he ought to be sworn in. Out of abundance of caution, my lord, Mr. Masengeli has filed an affidavit, which is on record, dated 20th September 2024, containing documentary and evidentiary material that he intends to rely on together with his own statement to improve the credibility and the cogency of his apology. We do plead and pray that the court down directs that Mr. Masengeli here is present be sworn in.
Just a minute. I've not made
You're not yet done.
I have not, just a minute. I have not made a decision. You will allow me. You have made submissions and you're already asking your client to get to the witness box. Sorry? Now, I don't want the back and forth because if we continue like this, we will not end these proceedings.
Yes.
I thought I'd given the Law Society an opportunity to speak.
Yes, my lord.
And what Mr. Miller and Mr. Owola were doing was a rejoinder.
Yeah.
Isn't it?
Correct, my lord.
So why don't you then allow me to make a decision?
Yes.
Isn't that the order of things?
That's it, my lord.
Yeah.
It's only that, my lord, they introduced some new facts.
Which one?
The affidavit. That was fact that we just learned about the affidavit.
It was not served.
Yes, it was served.
Was it served?
It was served. Though
When?
You can leave it at that.
When was it served?
Steady.
My lord, for purpose of this point, just go ahead.
Yes. Let me just make a decision on this. Then.
Just for the record, we served the affidavit. And an affidavit. We served the affidavit.
But you will understand that when in a proceedings of this nature, when one is summoned before the court, you not just rely on documents, because the court will also want to observe the demeanor of that particular person.
Yes, my lord. Yes. And that's why it's here, my lord.
So it's not a question of filing documents. It's a question of complying with the order for the court to find out exactly what was happening from the person. But the issue here is whether or not I should allow Mr. Masengeli to explain to the court why he has been deliberately defiant in disobeying the summons of this court.
Malone enriched the record. Solicitor General has joined us.
Leaving Mr. Hag.
Yes?
He's in court.
Who?
He's come to leave Mr. Hag.
You should be researched.
Okay. The acting inspector. So who has joined us, Mr. Abbey? The Solicitor General. All right. Thank you. Welcome.
He comes immediately after the Attorney General.
Now this is the decision of the court. The issue before me, or before the court, is whether I should allow Mr. Masengeli, the contemner who is before the court, to explain why he deliberately disobeyed the orders of summons by the court, which led to his conviction and sentence. The Law Society of Kenya, led by the President Emeritus Nelson Havi, has urged me to deny Mr. Masengeli the opportunity. He has revealed that he has revealed to this court from the bar that the missing persons have now been released, and all I should do is to allow Mr. Masengeli to confirm that he has complied with the orders of habeas corpus so that these proceedings can come to an end. Additionally, he has argued that Mr. Masengeli has filed 2 applications before the Court of Appeal where he has appealed against a conviction and sentence, and one where he seeks an order of stay of these proceedings. Mr. Dan Manzo has argued or submitted that the court is now functus officio, since the jurisdiction of this court now rests with the Court of Appeal, has now been vested with the Court of Appeal following the filing of the 2 appeals. This position has been strongly opposed by counsels for the first respondent, Mr. Miller and Mr. Ogola, who have argued that the court gave a coercive order which end compliance requirement. Further, the proceedings before the Court of Appeal are intended to deal with the conviction aspect and not the sentence. In making a decision on the issue before me, I must make a reference to the sentence of the order I made on the 13th of September 2024. In sentencing for contempt, there are normally 2 ways of punishing a contemner. Okay, 2 major ways. The court can choose to adopt a purely punitive approach, or can choose to use a coercive approach in which it includes what is known as the purging conditions. The coercive approach gives the contemner the opportunity to save himself from punishment, the equivalent of purgatory in religious circles, so that if the contemner complies and fulfills the obligation required of him by the court can weigh and consider whether he has cleansed himself of the original sin. In my ruling on the 13th of September 2024, I had this in mind when I included condition number 4, which stated as follows: the court nevertheless considers it desirable to impose a coercive order as opposed to the punitive order. In this regard, Mr. Gilbert Masengeli can avoid serving the sentence if he complies with the direction to obey the court summons. I thus suspend the sentence for 7 days only. The acting Inspector General can redeem himself by availing himself before the court in person to answer to the issues he has been avoiding within 7 days. In default, the sentence shall automatically become effective. Having stated as much, and the contemner having availed himself before the court before the lapse of the 7 days, I would be going against my own orders if I deny him audience as urged by the LSK. This is a court of justice and must act fairly at all times towards those that appear before it. Mr. Masengeli is entitled to be heard by virtue of this court order. The Court of Appeal has not taken away the jurisdiction of this court, for it has not issued any order being barring this court from hearing Mr. Masengeli. This court is not functus official either, as the sentence was not purely punitive but coercive, laced with purge conditions that the court reserved to consider before the sentence becomes effective. I will thus allow Mr. Masengeli to take to the stand and redeem himself.
My Lord, can you give directions on which side?
He must be on the dock.
My Lord.
Yes.
Purely on procedural matters.
Yes.
Stemming from the natural right to challenge that case.
Yes.
The petitioners reserved the right to cross-examine.
My Lord, with your kind permission, this is a matter between the court and the contemnor, and it is strike law that the petitioners have no right to cross-examine.
Okay, let the order.
Sorry, that cannot be the premise. Because if it's just a minute, I have a right to that. If he insists that we ought not to be here,
Yes.
we may as well walk out and
Okay.
go.
Okay. Let me do this, Mr. Harvey. Kindly listen. Let him explain. Immediately he has done that, I will seek. I'll seek what? Submissions from you on whatever issue you want, then I will rule on it. But for now, let's just follow the order. Let's hear him.
My colleague has actually made a
Yes.
request in advance.
Yes.
It is taking court from the Bible. We will reserve our right to cross-examination.
You will reserve the right to cross-examine, but let's first hear him. Then we can see whether it is necessary for you to cross-examine. Because you see, why do you make the decision to cross-examine before you have even heard what he says?
Precisely, my Lord.
No, a prudent lawyer
No,
must
just wait.
necessity
Just wait.
convey to the court what he intends to do.
Yeah, just wait until he does it, then we will consider.
My Lord, may I seek your leave?
Yes?
May I seek your leave to leave the court?
Very well, thank
Mr. Mutinda and Mr. Bita
It's okay.
will appear. Thank you so much.
Okay, Annette, swear the witness. Swear him.
So you repeat after me. I swear by the name of the Almighty God.
I swear by the name of Almighty God.
I swear by the name of the Almighty God.
I swear by the name of Almighty God
That the evidence I shall give.
that the evidence I shall give
Touching the matter in question.
touching the matter in question
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
You can start with your full name.
Kindly tell the court your full name, please.
My name, Gilbert Masengeli, Deputy Inspector General of Administration Police.
Can you tell the court the specific roles or role that you have been serving within the Inspectorate of Police?
My Lord, some of my duties and responsibilities is border security, ensuring that our borders are safe from incursion within and without for the safety of the Kenyan, my Lord.
Now, you have sworn an affidavit dated the 20th day of September 2024, which is here. Is that correct?
Yes, my lord.
Affidavit dated?
20th of September 2024.
You've not been served with this affidavit?
It's been forwarded to Rebecca's phone 5 minutes ago. So they'll be sent. Don't be expected to read an affidavit from the phone.
Would it assist if I gave you time to go through the affidavit? Because I can adjourn briefly so that you go through it, if that is what you want. Because basically what he's trying to say is he's going to rely on some of the information in the affidavit. Is it possible for me to allow you to go through that affidavit? I have a copy here, but I would, if you don't mind, I could ask my court assistant to have it photocopied by the court.
Hello, there is a return of service.
No, let's not get to that. We just want to do things in the right way. Yeah. Yeah, I just wanted them to get a copy. Mr. Nelson Avi, I want us to agree. Can I adjourn for 20 minutes so that you can, maybe 20 or 30 minutes if you wish?
I think 20, even 15 would be good.
Very well. So in So let's, from good order, let's adjourn for 20 minutes. We allow the petitioners to peruse the affidavit, and then we can proceed after that. I think it's important that we proceed when we are on the same wavelength. Yeah. Kindly let's adjourn and.